Thank you, Terry. Good evening to Justice and Mrs. Wallis, the Brody family, members of the judiciary, friends and colleagues. I've been given the important and very complex task of introducing someone who actually needs no introduction. But bear with me as I just take you through the background of Justice Wallis, just to remind ourselves of the importance of the legacy that he leaves behind. We are honored to have retired Justice Malcolm John David Wallis join us to deliver the inaugural Group 1 Jules Browde public lecture. Justice Wallis hails from sunny KZN, and he obtained a BCom, LLB cum laude, and PhD from the University of Natal. He joined the bar in 1972, specializing in maritime, commercial, labor, and company law. During his time at the bar, he was actively involved in bar governance, culminating in him chairing the GCB from 1994 to 1997. Justice Wallis took silk in 1985 and was elevated to the KZN bench in 2009. He joined the LAC in 2010 to 2011 and was appointed to the SCA in 2011. During his time on the bench, Justice Wallis quickly established himself as one of our leading jurists. One needs only to look at Endumeni and appreciate the impact of that decision. I won't say more than impact of that decision on our law on the interpretation of written instruments. Now turning to the topic of today's lecture. As of late, self-review has become what the Constitutional Court and the SCA has described as the burgeoning area of our law. Our courts have repeatedly emphasized the duty on state functionaries to go to court to correct unlawful decisions in the public interest. They have emphasized the value of open, responsive, and accountable government, the lodestar guiding the development of legality jurisprudence in respect of state self-review. However, as the SCA recently lamented in the Governmental municipality matter, and I see Justice Nafsa sitting here, the principle of self-review is not only open to abuse, but in many circumstances, it could be highly prejudicial to innocent third parties, for a variety of reasons, not least of which is the excessive delay, which is usually experienced before a functionary comes to court for self-review. The problems associated with self-review are compounded when one applies the well-entrenched principles of Oudekraal and Kirland. You'll all know that the Oudekraal principle deems that an administrative or executive decision continues to have legal consequences until it is set aside by a court on review. Despite the Oudekraal principle being well entrenched, a handful of our judges have already conveyed unease with the principle. For example, in the minority judgment of Jafta J in the Merafong decision, he considered the principle to be problematic because it was at odds with the principle of legality, and one can immediately understand why. Tonight, Justice Wallis will consider the Oudekraal principle and share with us his perspective on whether or not the principle should be revisited. I give you Justice Wallis.
Retrieve my computer from Denise. Somebody's pen?
Yes, it's a good pen.
I've got one here too. Okay. Well, thank you for that introduction and summarising my entire paper tonight. Wrongly. Sorry, Commissioner. Couldn't resist that. but at my age, I do enjoy a little bit of flattery when I can get it. I would like to congratulate Mohammed, even in his absence, his team and Group 1 for planning and organising the lecture. When I started at the bar in 1973, Jules Brody's name was already halfway up the list of silks. His reputation went before him. It was not only a reputation for his skills as an advocate, but for, and I quote, his integrity, his commitment to the bar as an institution, his values, rooted in his respect for the dignity of persons, and his public commitment to the struggle for a better life for all. And that is how Arthur Chaskelson described him. Those are the qualities that led me, when I was chair of the GCB, to ask him to join me in presenting jointly the GCB's submissions to the Truth and Reconciliation Commission. And it's a tremendous privilege for me to have been asked to present this lecture, honouring his role in establishing Group 1 and in the wider pursuit of justice in South Africa. But it's also, if you don't mind my saying so, a further privilege that, Selma, you have graced us with your presence tonight. You and Jules shared a vision of a different South Africa, where human dignity was recognized and it was valued. And there's absolutely no reason why you would remember a young advocate who stood in awe of the work that you and the redoubtable Helen Suzman did to promote those values. But if you have at home and you look at page 51 of Values Alive, the tribute to Helen Suzman, you look at page 51, you'll see a photograph of you and Helen and Max Borkum on polling day at Houghton in 1974. Enjoy that memory, then have a quick glance at the photograph on the left-hand page. And when you spot that young advocate with shoulder-length hair, I think you'll at least agree my appearance has improved. Now, Pete's original suggestion, Bobby, you were in that picture too, so Pete's original suggestion was I should say something on interpretation. But I've learnt after many years in practice and now on the bench, never miss an opportunity to advertise. So, and I don't want to ruin your anticipation of my forthcoming article in the Potchefstroom Electronic Law Review, which deals with Capitec and the University of Johannesburg. And it's in production at the moment. They've asked me for the money. I chose self-review because of the stark changes which Commissioner mentioned, and also for the considerable confusion it's brought about in recent years in our law governing judicial review. Had I, before choosing it, encountered Giaquino's description of it as a particularly problematic issue, posing one of the most difficult topics South African administrative law is facing, I might have looked for something easier. But I'll do my best. Seems every time I commit myself to doing this sort of thing and talking on administrative law issues and judicial review, I see Cora Hookster sitting over there sort of monitoring, okay, is he going to get this wrong again? It is a reality of all states that public officials and public bodies with attendant bureaucracies get things wrong. They do things they purport to grant rights without being entitled to do so. That's not new. It can arise from very mundane matters. Let's take the Transair case. Someone at the National Transport Commission inserted in manuscript on the license of Transair, a license to operate a non-scheduled transport business in South Africa, a clause which extended the license to, and I quote, the whole continent of Europe, Saudi Arabia, Africa, Cyprus, and Middle East countries. They'd asked for that, and the Commission had said no. But you'll be glad to know that government in those days worked as slowly as government still works, because it took the Commission 2 years to discover their error. And they only discovered it because Transair asked to have a Boeing added to the Cessnas. Okay. But the origins of self-review lie in that judgment and in Owen Rogers' monumental judgment as an acting judge in the High Court in the Pepcore matter. I think all people who are asked to act should be shown that judgment and reminded that that's actually what you're expected to do as an acting judge. All 300 and how many paragraphs of it is it, Owen? But reviews are usually and were usually historically brought on behalf of people detrimentally affected by the public bodies, the public authorities. And those cases where the public body itself would apply were extraordinarily rare. So unusual was this that when it first arrived at the then appellate division, the court was actually hesitant about characterizing it as judicial review at all. No doubt if you'd been around Cora, you'd have corrected your grandfather. But in the past 10 years or so, the Constitutional Court has created this novel but burgeoning species. It has become prolific, and it has recently, or relatively recently, been baptized as self-review. Although for me, the notion of a public official or entity's current iteration, arguing with its previous iteration about the legality of what you did then, conjures up for me a parody I once saw of a human resources assessment form, which had as the two lowest categories of communication skills 4, argues with himself, 5, loses arguments with himself. What is the driver of this proliferation of legal challenges by public officials and public bodies? It is, I'm afraid, the deplorable state of our public administration. The aims set out in Section 195 of the Constitution, a high standard of professional ethics, efficient, economic, and effective use of resources, etc., we can go through the list and get fairly depressed, are rarely encountered in practice. Incompetence and indolence are far more what we encounter, and as Daniel Pretorius has rather generously written, officialdom frequently perpetrates administrative blunders. You're saying it. And the work of the SIU shows that corruption and outright theft of resources is endemic. And regrettably, the litany of cases in this field suggests that many cases are far more than blunders. In the realm of public procurement, there are repeated cases of public officials knowingly and quite deliberately disregarding the legal requirements governing public procurement, starting Section 215 of the Constitution, the Public Finance Management Act. Don't need to take this thing away. Etc. And it was highlighted by Mohammed Navsa in the Government and Mbeki municipality case, and I commend to you paragraph 1 of his judgment. Because it seems to me, and when I talk to advocates about what they're doing in administrative law, that public officials and bodies wishing, for whatever reason, to escape the implications of what they've done in the past, whether it's letting a contract, giving a license, granting an approval, have become adept at trawling through the processes they adopted in making the original decision in order to find some kind of non-compliance that becomes a peg on which they can hang avoidance of their decisions and self-review if necessary. And the reasons for this occurring, when you read the papers, are often nothing to do with the merits and the benefit to the public of what they have just done. They appear to flow from changes in political leadership or direction. There's a new MEC, there's a new head of this department. The large number of leadership posts which are filled by acting appointments, who are desperate for those acting appointments to become permanent, even if the only purpose of that is to be charged disciplinarily and then to sit at home for 3 years and being paid your salary. But that's another matter. So they want to ingratiate themselves. They desire to benefit someone. There is corruption there. A belated endeavour, and it's always a belated endeavour, to suggest that the authority is now engaged in cleansing the Augean stables of their predecessors. Generally, there is a spirit, as we go month by month, year by year, within all the aspects of our public administration, that the old order must change, giving way to new every 6 months, 1 year, couple of years. But very rarely, as Tennyson thought, does that happen as a result of God fulfilling himself in many ways. Now, we need some legal mechanism to deal with it. Judicial review is the obvious candidate, but it's not that simple. Because our law relating to judicial review is not in a happy state. Elsewhere, I have described it as in a swamp of uncertainty. I don't have time tonight to explore the whole of the swamp, so the tributary of self-review is going to have to suffice. But a little bit of background. Judicial review is concerned largely with the actions of public bodies and their officials, those responsible for the administration of government towards the citizenry. Where they blunder, to use Dr. Pretorius's rather kindly description, the citizen challenges their blunders by judicial review. That's uncontroversial, and it was uncontroversial pre-1994. That was uncontroversial going back to the 1800s. Yes, the power of review was not as broad as we would like. Yes, the scope was inadequate, and frequently it was precluded by legislation. So the constitutional guarantee of just administrative action must be seen as an entirely understandable reaction to the abuse of administrative power that characterized our previous regime. The Promotion of Administrative Justice Act, commonly referred to as PAJA, largely incorporated and expanded the grounds of review at common law. There is a comprehensive, if rather clumsy, definition of what constitutes administrative action, and the Constitutional Court, with, on this occasion at least, the Supreme Court as a fairly loyal ally, has repeatedly said that challenges to administrative action must be brought under PAJA. Regrettably, neither court's deeds have always matched their words. Okay. After the interim constitution came into force, however, it emerged that the drafters had missed something. There was now a yawning gap in our law relating to judicial review, because many exercises of government power or executive authority that had always been subject to oversight and review by the courts, on the same basis, in the same way, in accordance with the same procedures as administrative action, were now excluded because they weren't administrative action. And that question, whether something is or isn't administrative action, has become a central feature of our administrative law, and not, I suggest, a good one. But cases involve challenges to the setting of municipal rates, establishment of rugby commissions, bringing into force of a statute, all demonstrated the need for the Constitutional Court to produce something, and the rabbit they produced out of the hat of the existing principle of legality was a newly minted principle of legality, which required exercise of public power to be lawfully authorized and exercised by lawful authority. I use those expressions from Baxter's work on administrative law. And then the court has adapted it into a rather broader concept for reviewing exercises of public power other than administrative action. But the two, legality and PAJA, are not harmonious. Instead, we have two streams of judicial review. They sometimes flow in the same channel, sometimes they don't, and they create the swamp I was talking about. And if the resulting jurisprudence is anything to go by, general confusion reigns, particularly in people deciding where to launch their canoe, whether the paddlers are judicial, academic, or practitioners, whether they should launch their canoe in one stream or the other, or perhaps use one boat and try and navigate both streams at once, which seems to be the favoured option. And in the midst of all this, in roughly speaking, although Oudekraal was earlier, the last dozen years, self-review has evolved and it has raised a number of questions. When is it required? Is it obligatory? Who can bring it? What is the basis for it? Where does it fit in the greater scheme of judicial review? And the cases initially tended to say, in answer to those questions, it's always required. It is obligatory. The public authority or functionary can bring it. It's a Padger case. Recent developments in Kajima, the last answer has changed. It's a legality review. My thesis tonight is to suggest to you that all of those answers are in some measure incorrect. It starts with Oudekraal, or as Dr. Pretorius has convincingly demonstrated in my view, a misunderstanding of Oudekraal in the two articles he's written about it, one in the South African Law Journal, one in the Stellenbosch Law Review. Indeed, if one looks at the references to the case in the second edition of Cora's book on administrative law, there's actually very little indication that it was an overwhelmingly important case. Pepcor was given a far bigger blurb in those days, but it has assumed a life which I think is probably not justified. Remember the facts. Oudekraal Estates owned a piece of land on the slopes of Table Mountain, the 12 Apostles above Camps Bay. In 1957, the previous owner had obtained permission to lay out a township. Permission was subject to lodging a plan within 12 months or some extended period, and eventually after some extensions the plan was lodged, the Surveyor General approved it, and it was registered in the Registrar of Deeds office. In 1996, Oudekraal Estates, having now acquired the property, submitted to the Cape Metropolitan Council an engineering services plan based on the approved and registered plan as a precursor to proceeding with development. And the council, the Cape Metropolitan Council, not the administrator, not the Registrar of Deeds, not the Surveyor General, rejected it on the basis the administrator's approval had lapsed, the registered plan was not lodged timelessly, and the extensions which had been granted were all invalid. So Oudekraal Estates went to court and said we want a declaratory order that we have development rights. They're of full force and effect. And we're entitled to create subdivisions. On appeal to the SCA, the court held that the original consent was unlawful because in granting it, the administrator had either been unaware of the presence on the site of kramats and graves of historic importance to the Muslim community, or had disregarded that fact. However, it also said that this didn't entitle the council to ignore the administrator's grant of permission, because Oudekraal had the necessary permission to develop a township, and that fact, not the validity of the administrator's decision, was all that it needed to establish when submitting an engineering plan to the council. The council's task was to assess engineering service plans for townships which were approved. It was not to get involved in a legal question of determining whether those approvals were lawful. If it thought that, it needed to challenge them by way of review. And that's what Oudekraal 1 decided. And it's important that people dealing with the public administration are entitled to rely on the decisions they take, not to be subject to the decisions being revisited or withdrawn if officialdom has a change of heart, or if at a later stage another official takes a different view of what their predecessor has done. And as with so many things in the law, we sum it all up in the Latin words functus officio, meaning the official has performed their function, and absent any power that has been conferred upon them to change it or alter it, revisit it, everybody is bound by it. And the everybody is not only the officials, but also everybody out there in the world is bound by it so long as it stands. That's the corollary to it. And if they don't like it, then they must bring an application for review. And the court summarized the position and said this: until the administrator's approval, and thus also the consequence of the approval, is set aside by a court in proceedings for judicial review, it exists in fact, and it has legal consequences that cannot simply be overlooked. And it goes on, but I'm aware of time. The issue of self-review enters through a side door, because review is usually a direct attack on the validity of what has been done. Somebody brings proceedings and says, that's wrong, I want it set aside. But sometimes things happen the other way around, because the public power, or somebody else, not necessarily a public power, tries directly to enforce against the individual a decision, the validity of which is challengeable, as was the administrator's decision. And we call that a collateral challenge. Comes in from the side. But it's collateral because the only response that is available to the person against whom enforcement is sought is to say, but that rule, law, whatever it is invalid. If it's valid, I'm stuck with it. I'm in trouble. And the usual instances where one encounters that are in regulatory and criminal cases. And somebody seeks to hold somebody liable to a penalty, to a criminal conviction, and their response is to say the regulation is illegal, it's invalid. And the illustration is, of course, the famous one of Mr. Boddington. Mr. Boddington was a smoker. He was charged with smoking in a non-smoking carriage on a British rail train. And he claimed that the no smoking notices in the carriage were erected unlawfully, even though there had been such notices erected in carriages under the same regulation for 30 years. Everybody knew, you got on the train, you weren't allowed to smoke in those carriages. He did. And the court said he was perfectly entitled, when he was charged, to say to the magistrates, those no smoking notices are unlawfully erected. They don't bind me. Because otherwise, he would be left with no defense to the might of the state. Seems a trivial amount. The fine was a relatively small amount. But the court said, you've got to be entitled in those circumstances to challenge directly. And that's a collateral challenge. It was, of course, a Pyrrhic victory for Mr. Boddington, because with very little further ado, the court said, there's nothing wrong with those notices at all, and you're guilty of smoking in a non-smoking carriage. So the misunderstanding of Oudekraal arose because the passage I've quoted was construed as meaning that in every case where the validity of an administrative action or an exercise of power was in issue, the action or exercise of public power would trump everything unless and until it was set aside. That's not the law. The problem was aggravated in Kirland because that was seen as doubling down on this erroneous view of Oudekraal. If you want to know why I think it's not the law, go and dig out the South African Law Journal and the Stellenbosch Law Review and read Dr. Pretorius's articles. Broadly, I agree with them. Kirland built hospitals and ran hospitals. And they applied for consent for two new hospitals, one of which is what is now Geberge. I get that approximately right. And the other is Jeffreys Bay. Under the relevant regulations, the Superintendent General of Health, Mr. Boyer, was advised that the application should be refused on the grounds that there was enough private hospital accommodation in those places. He prepared a letter to that effect, but he didn't send it because he was involved in a motor collision and he was off sick for 6 weeks. In his absence, the acting Superintendent General, Dr. De Lisa, was instructed by the then MEC for Health in the Eastern Cape to approve the applications because she was under political pressure to secure their approval. The instruction was obeyed, the letter was written and delivered to Kirland. When Mr. Boyer returned, he was first confronted with an application to increase the size of the two hospitals, turned it down saying there's a surplus of beds, And then after about 8 months, he wrote a letter saying, the department's withdrawn those approvals. If you don't like it, go and talk to the new MEC. The new MEC, they did go and talk to and said no. So Kirland went to court and said, you can't do that. We want an order setting aside the withdrawal of the approvals. And like Oudekraal, Kirland was not a case of self-review. Not at all. It was a direct, conventional, own interest review of something that affected Kirland. On the papers, the only issue, this was common cause all the way through, except for the minority judgment in the Constitutional Court, was that the only issue was whether Mr. Boyer was entitled to withdraw those approvals. All the courts, it was said, no, he wasn't, because effectively he was functus officio. He was stuck with it. The minority judgment is what actually caused Kirland to go off in the way it did, because the minority held that the validity of Dr. de Liza's approvals was raised, and it used that as a springboard to challenge Oudekraal, which, looking at the jurisprudential history, if I can put it that way, it appears that Justice Jafta, who wrote the minority judgment, had a fundamental objection to Oudekraal. Whether it was a good objection or not, I'm not going to say, but he had a fundamental objection. And that affected the terms in which Justice Cameron wrote the majority judgment. And it's very important to read that, because judgments are not written in a vacuum. You've got to understand they're addressing a particular situation, particular problem, and as every judge here has undoubtedly had some higher court or academic misrepresent what they're actually deciding, I do urge you to trust that what the judge says that they're deciding is what they're trying to decide. They may get it wrong, but that's what they're trying to decide. And he put it this way in the opening paragraph of his judgment. Can a decision by a state official communicated to the subject and in reliance on which it acts be set aside by a court even when government has not applied or counter-applied for the court to do so? Differently put, can a court exempt government from the burdens and duties of a proper review application and deprive the subject of the protections these provide when it seeks to disregard one of its own officials' decisions? Pointed out that the main judgment answered that question yes, and he said he disagreed. Even where the decision is defective, as the evidence here suggests, government should generally not be exempt from the forms and processes of review. It should be held to the pain and duty of proper process. It must apply formally for a court to set aside the defective decision so that the court can properly consider its effects on those subject to it. Now, that was what Justice Cameron was dealing. And although I don't think this is what he intended, statements such as that the government must be held to the pain and duty of proper process, and it must apply formally for a defective decision to be, may not be ignored and must be set aside, that reinforced the misunderstanding of Oudekraal. It suggested that this is all obligatory, and that's the only way to go. But he used the word may, but that was ignored. The judgment doesn't explore in what circumstances such actions may have legal consequences, and the corollary, which is in which circumstances it may not have that effect, which is very important. And two other issues arise from this passage, and they've come from the reference to conduct that is vulnerable to challenge. Because when it matters, and it didn't matter in that case, because they weren't going to decide the point, when it matters, saying conduct is vulnerable to challenge immediately forces you to ask two questions. challenged by whom, and vulnerable on what grounds. Neither question was asked, neither question was discussed, and they haven't been dealt with in later jurisprudence. But the first raises the vitally important issue of standing to bring proceedings. And there is no reason why we should assume that all public bodies necessarily have standing to bring proceedings. We don't assume that about any of the people in this room or any of the organizations that occupy these buildings around here. If you want to come and bring review proceedings, you've got to show you've got standing. Public bodies should not be any different. If we look at administrative action and we look at standing, standing is what is given to people who have interests protected by the law, or given to people who can legitimately claim to be representing other persons who have interests protected by law, so are entitled to bring legal proceedings on those grounds. And in the context of administrative action, exercise of public power, that the right to bring proceedings generally vests in those in relation to whom the action or exercise of power is taken and who are affected by it. The definition of administrative action refers to decisions that adversely affect the rights of any person. And bear in mind that in cases like Transair, Pepkor Retirement Fund and the FSB, the courts held the public bodies had standing in their own right, not on behalf of somebody else, not representative standing. And they are the people who had to be prejudiced. And the absence of prejudice is why the local authority in Raja and Ventersdorp municipality was non-suited. The same logic does not necessarily apply to a decision such as that in Kirland. I'll come back to that in a moment. Pepkor holds that whether a public body will have standing depends upon the legislation involved and the nature and functions of the public body. And I stress that's the own interest standing. But there's nothing in the judgment in Kirland that suggested that there was any reason why the Department of Health should be given own interest standing in that case. Whether its application should have been approved turned upon a judgment whether those places were oversupplied with hospital beds, private hospital beds. No particular public interest in that decision. There's nothing in the judgment to indicate that having granted approval, the Eastern Cape Department of Health had to do anything, had any supervisory role, any responsibility for what went on in a private hospital. Either it would attract patients and medical practitioners, and it would provide a service to the community, in which event the judgment of the department was simply wrong. Or it wouldn't, in which event it would be commercially unviable. It's difficult to discern the interest that would be vindicated by overturning Dr. DeLisa's decisions on review, other than saying, Dr. DeLisa, you were, as Clive Plaskett said in the SCA judgment, you were weak and cowardly in not doing your job properly, or saying to the MEC you ought to lose your job. Well, she had lost her job anyway, so be it. The critics of Gajima, which is the later case, point to Section 38D of the Constitution and the proposition that sometimes people may be entitled to litigate in the public interest. Now, this is going to come as a horrible surprise to all of you. But while we all have an interest in good government, that does not give us legal standing to engage in litigation whenever any department of government infuriates us. It's equally not the law that any and every departure from the path of rectitude by a public authority or official confers upon each and every citizen public interest standing for the purposes of Section 38D of the Constitution. And if you think I just sucked that out of my thumb, I suggest you have a look at the Constitutional Court's own judgments on when Section 38D standing will be given, which say that the court will be circumspect in granting public interest standing, and it has identified various factors, none of which apply in the circumstances of Kirland. And none of those factors suggest there's a blanket entitlement of public authorities to engage in self-review. So I don't think standing is a given, and that's important. Whether it's vulnerable to review depends on the grounds of review, and that's particularly difficult, because grounds of review generally fall into three categories. It's either, was there lawful authorization for the action? Was there lawful authority, that is, was the person or body who exercised the power entitled to do so? And then there's procedural irregularity or impropriety. Now, the first two primarily raise issues of law and are the least problematic because they correspond more or less to the equivalent cases under both PADGA and legality review. A public body was not authorized to act as it did. It can't be compelled to do so. I could give you examples, but time hastens on. But the last ground speaks to that time-honored distinction between appeal and review. It says there's a difference. Appeal asks whether the decision was correct. Review is concerned with the process of decision-making, usually expressed as being whether the making of the decision was infected by procedural irregularity or impropriety. And I know that gaps and distinctions like that can be a bit amorphous in difficult cases, but most of the time they're fairly helpful. And I think most of us are probably aware or familiar with Corbett's summary of what needs to be proved. Decision was arrived at arbitrarily, capriciously, mala fide, as a result of unwarranted adherence to a fixed principle, etc., etc. Probably all read that at some stage. Most of those grounds are identified as grounds of review under PADGA. To some extent, they are grounds of review under legality, but not entirely. And there's no difficulty applying them when people complain about what has been done to them by public authorities. But it's not clear-cut that one can or should allow them to be invoked by public authorities in support of a self-review. Why should the authority be entitled to upset its past decision on the basis of its or its officials' own misconduct? It seems to me there's something distasteful in saying that because official A took account of irrelevant considerations or ignored relevant considerations or just engaged in a bit of favoritism of some sort or other in approving a plan or a license, that the public authority can come along later and challenge the validity of what was done. I'm not dealing with a person who was involved in, I'm not dealing with corruption or bribes or anything of that sort. But I'm talking about the person who goes and makes an application, and because of that sort of irregularity, they get what they asked for. But there's no third-party challenge. The beneficiary hasn't behaved improperly. Why should the public authority be entitled to set aside its own decision? Well, I'm not the first to have said that, because in 1915, Wessels J. said, I don't think it is advisable to allow an official to exercise his discretion and make a grant, and then, after having done so, to come to court and ask that what he has done should be set aside on the ground of his own carelessness or ill use of discretion. That's exactly the point. It was argued before Owen Rogers, acting judge, and he carefully said it wasn't necessary to decide the point. Probably wisely in the circumstances. But there is, I think, a problem in suggesting that public bodies can come along and invoke procedural irregularity or impropriety, or even notionally. Of course, we didn't give the person a hearing. We gave them the license, but we didn't give them a proper hearing. So now let's start all over again. I find that a rather difficult situation, and Kirland illustrates it, because the judgments at every level, go and read them, focus entirely on what Dr. DeLisa didn't do, didn't show any courage, and what the MEC did do. Of course, it comes as a huge surprise to all readers of the judgment, or possibly only to those who sit in higher judicial office, that occasionally politicians nudge civil servants to take decisions which will suit the politicians' political instincts. I think it's been known to happen for thousands of years. But insistence on the application of self-review affords a little bit of procedural protection. But the more important antecedent question is why, in any event, Kirland should be the party to bear the brunt of the MEC's misconduct. I don't understand why the law should reward the wrongdoer for its wrongdoing by upholding a review and levying adverse consequences on the innocent party. We don't usually do that. And I'm unmoved, I'm afraid, by the argument that it can be resolved by way of just and equitable relief under Section 172(1)(b) of the Constitution. There's no reason of public policy or equity why, if I can use the rather mealy-mouthed language of armies, Kirland should even potentially be collateral damage of the MEC's and the department's misconduct. Why them? Nor should it have to be dependent on the judge's sense of what is just and equitable, because I fear that the minority judgment showed that there are judges who regard as more important reasserting proper administration than considering Kirland's interests in having been granted rights. I have a difficulty with that. Why? But judges do have different views. So why should it be problematic? Why should that be a proper ground for doing things? And I suggest there are sound reasons of public policy why that shouldn't be the case. They're grounded in the structure of government at all levels and other organs of state. The fundamental point is this: whatever internal or structural changes are put in place or occur in government, the institution of government at any level remains the same yesterday, today, and tomorrow. When dealing with the city of Johannesburg, we do not care which coalition governs the city or who wears the mayoral chain this week. Our dealings as citizens, most of you probably are citizens of Johannesburg, are with the city. And we want the city to respond, whoever is actually sitting in the council chambers, whoever holds the particular post of director of this department or that department. And it's a principle that the existence of government entities is continuous, and the citizenry deal with government on the basis that the decisions made before bind your successors afterwards. And that is why the Constitutional Court, just in case you think this is Malcolm Wallis going off on a rant of his own, not based in the law, the Constitutional Court, as long ago as Walker versus the Pretoria City Council, said you can't withhold your rates and taxes because you don't like what is being done with them. Because it's continuous, it's ongoing. It's why the Constitution, like every one of its predecessors, going back to 1910 in this country, has had transitional provisions. And I would remind you that the first transitional provision in Schedule 6 of our Constitution is that all law that was in force at the time of the inception of the Constitution remained in force, subject to specified and limited changes. And that is why when there's a change of political administration, the new administration is bound by the existing commitments of the old in regard to the citizenry. And I don't believe the law should facilitate organs of state avoiding that principle. Now, when Justice Cameron wrote his judgment in Kirland, he was inclined to think self-review was a padger, was administrative action. Of course, that couldn't be completely correct, because in instances of public power that weren't administrative action, you had to deal with them under legality. No matter how forcefully you wield the shoehorn, you can't get everything into administrative action, and we know that. And it could have emerged more clearly if some of the bad actors during state capture had become repentant and good actors and said, please set aside what I've done. But they didn't. As we well know, they still don't. But in Gajima, the Constitutional Court, including Justice Cameron, said that self-review cannot be administrative action under Section 33, and they put it under legality. They limited their conclusion because they said that didn't deal with the situation in Oudekraal. Well, of course, self-review doesn't deal with the situation in Oudekraal, and Oudekraal doesn't deal with self-review either, so that didn't matter. And they said it didn't deal with Section 38D cases, public interest cases. But with respect to those who have thought otherwise, that simply introduces even more complexity. If you go along the 38D route, it ignores that administrative action is an exercise of state power, whereas in self-review, the reviewing power is both the actor and the victim. It also falters in its failure to identify the public whose interest it is protecting. Some of the articles place reliance on the judgments in Giant Concerts and Tulip Diamonds. By all means do so. But those are not cases of public interest standing. They are self-interest standing. Go and read them. And a self-review doesn't appear to satisfy any of the requirements for public interest litigation in Lawyers for Human Rights against the Minister of Home Affairs. The one case where, subsequently to Gajima, that route has been followed is CompCare, but that is where the person said, I'm bringing this under Section 38D, and that was not challenged. And the SCA said, well, okay, we'll go along with you. The critics don't identify how conduct, which is the subject of self-review, even comes within the definition of administrative action. In Padger, of course, nobody likes looking at the definition of administrative action in Padger, but it is there. And it requires the action must adversely affect the rights of any person. So if you want to bring a public interest claim, you've got to identify the people whose interests were affected. And I ask again, what interests are affected by granting Kirland the right to build hospitals? Or Gajima an extension of its contract to provide technology? Or in a case I will come to at the end, Asler Construction a contract to build much needed houses, where no tender process had produced another contractor to do the building. None is apparent to me from poring over those judgments, and many other cases in preparing this lecture, but perhaps my advancing years mean that my eyesight has biblically grown dim. But anyway, the Constitutional Court has reaffirmed Gajima. And my concern at this point is the proposition you can just treat self-review as just any other case of judicial review under illegality. Whilst I think Gajima was probably right, it doesn't help to make it a legality review, because the organ of state is doing something different. In legality review, it defends itself against allegations of failings and impropriety. In self-review, it seeks to remedy that and cries mea culpa. So treating the two as the same ignores that they are fundamentally in character different things are happening. And if different things are happening, it's a good idea to treat them as different. But it also runs us into the problems with a couple of settled aspects of our law governing review and its adoption in Padger, and that is that the grant of relief is discretionary and that a claim to review can be resisted at a preliminary level by saying there's undue delay. And we've seen the difficulties that that can cause. It was a problem in Kirland, but take the other case, where the local authority sets a tariff for the supply of water. The minister intervenes and sets another tariff. The local authority is told the minister's got no power and says to the consumer, well, you're going to have to pay us what we say is the tariff, otherwise we'll cut off your water supply. It's a straightforward issue. Was the minister entitled to override the local authority, set her own tariff, or wasn't she? Two crisp legal questions. What did the Act say? And was it unconstitutional if it gave her that power? And those are the facts of Mericon against Anglo Gold Ashanti, as everybody will have realized. It dragged on from 2005 to 2011, when Anglo Gold went to court over it, because it was out of pocket to the tune of some 31 million rand. It asked for an order that the minister's tariff was the correct tariff. That was what it was looking for. The High Court thought the minister was entitled to set a tariff, but if it was incorrect, her decision was valid until set aside by a court. Got to the SCA dismissed the appeal because the minister's actions in setting her own tariff had not been set aside on judicial review and remained valid until that occurred. The claimant sought an order that the minister's tariff was applicable. The SCA said it wasn't open to Merifong even to raise that by counter-application. Got to the Constitutional Court, and the Constitutional Court said, no, they could raise it by a collateral challenge. But the relief you're entitled to is to be sent back to the beginning. Anybody thinking this resembles snakes and ladders, you're right. Go back to the beginning and proceed to file affidavits in accordance with Rule 53 so that we can canvass your reasons, the delay, and everything else. Now, to one or two outsiders who are present, and I hope all the lawyers present, it might strike you as a little odd that after 5 years of litigation, right the way through the court structure of South Africa to the highest courts of the land, the question whether the local authority or the minister was supposed to set the water tariff was unresolved. Not only was it unresolved, the two top courts had declined even to address it. And frankly, it seems to me that's not just odd, but a little bit perverse. Because the central finding by the majority in Merifong was the council was entitled to raise its issues with the minister's actions by way of a collateral challenge. And in Oudekraal, the SCA had said that where a party is entitled to raise a collateral challenge, the court has no discretion to refuse to permit it to do so. Okay? And there's good reason for that, because of the basis of collateral challenge. But AngloGold wanted an order that the minister's tariff applied. Merifong said, no, it doesn't, because the minister hasn't got power to set a tariff. Our tariff applies. If Merifong was right, the court couldn't grant the order that AngloGold was asking for, because it would be enforcing something that was unlawful. That is, a tariff set by somebody who had no right to do so any more than any of us in this room have a right to set that tariff. I'm amazed that if we did so, any court would proceed to hold that until our setting of the tariff had been set aside by a lawful decision, it bound. Oh, okay. Try that sometime, see how it works. Nonetheless, the matter went back, and it was to explain delay. But delay couldn't affect the matter. Because let's test it. It goes back, and the court says to Merifong, we're not prepared to overlook your delay. So your self-review is dismissed. AngloGold bulks itself up, and emboldened, it says, can we please have the order we asked for in the notice of motion that the minister's tariff applies? And the judge, who, as all judges do in the lower courts, go to bed reading the judgments of the Constitutional Court, emboldened by having read last night Cusa versus Tao Ying, and having been told by the Constitutional Court that it is contrary to the principle of legality to decide a case on an incorrect view of the law, would retort to AngloGold Ashanti, but what power has the minister got to set tariffs? Isn't that the exclusive function of the local authority? And so the carousel would continue to turn. Curiouser and curiouser, cried Alice. Now, I could go on to SEMA, which is particularly troubling, Oricon, Magnificent Mile, the procurement cases, but Buffalo City needs a mention. Because Buffalo City, the local authority, concluded a contract with ASLA for the building of homes. An extension of the building program into a different area was put out to tender 3 times, and the tender failed every time. So the then city manager wrote to ASLA and said, look, this extra area is included in your contract. Well, you've got it. A year later, that was then confirmed by the chief financial officer. A year later, the same chief financial officer, now the acting city manager, wrote another letter saying, we've concluded that the extension was unlawful because it was concluded without a lawful tender process. Sorry about that. Of course, must have been aware of that from the outset. Now, while this was all going on, Astor carried on building houses. The engineer carried on inspecting the houses and issuing payment certificates. So the municipality just didn't pay them. And so Astor went to court and sued on the certificates, provisional sentence. Response by the municipality was a self-review. Please set this contract aside. The High Court set aside the contract, dismissed Astor's claim for payment. Astor trailed its coat up to Bloemfontein, and Bloemfontein said, no, the local authorities take far too long to come along and do this. It's out of time under Padja. Overruled the High Court. Up it went to Braamfontein from Bloemfontein, and the Constitutional Court was unanimous in agreeing that the delay in bringing the self-review was unreasonable and should not be overlooked. But for the minority, that was enough, and they said, that's fine, well then we'll refuse leave to appeal. Because I think they were looking down the road and they was thinking, there be dragons. But the majority went down the road and encountered the dragons. The dragon of section 172(1)(a) of the Constitution, and they decided that it was absolutely essential, notwithstanding what they'd said about taking too long, for the court to declare the contract for the extension invalid, because the Constitution said any unconstitutional conduct must be declared invalid. So they did so. But at the same time, in order to preserve Astor's right to receive payment under the contract, they declined to set the contract aside. So the contract was invalid but enforceable, and Astor could sue for money on it. I've been in the law a long time, but that is a new and unique meaning to the notion of contractual invalidity. So where does it leave self-review? It's said to be a legality review, but legality review only to exercise of public power that aren't administrative action. Most cases where self-review is invoked, especially procurement cases, involve quintessential instances that would otherwise be administrative action. The result is the legal approach to review of the conclusion of a contract after a defective tender depends on whether the review is brought by a disappointed tenderer over there, or whether it is an act of repentance by the person who let the tender. So instead of two streams of judicial review, sorry to say this, Cora, there are now three streams. And the third one contradicts both of the other two, just to be easy. And the court hasn't addressed the crucial issues of standing to bring a self-review. That's closely linked, as I tried to show, to the grounds of review. The picture of a newly repentant local authority meekly standing for a judge to explain that its decision to approve the sale of valuable land was taken arbitrarily or involved wrong facts or something of that sort might be appealing, but should it be entitled to rely on such misconduct to avoid the sale? It has no legal interest to defend. The reality, and this is the reality on the ground, people, is that public administration in this country at present is in such a dismal state that, particularly in public procurement, it is so deficient that finding a peg to hang a case of self-review on is simply a matter of going through what you bothered to put in the file. And when you bring the self-review, the motives for doing so are, as my colleague Mohammed Navsa said in Governor Mbeki, usually opaque and one suspects very often dishonest. And should we be relying on the delay or the judicial sense of what is just and equitable as the most important shield for the other party to the contract? And I suggest the situation actually cries out for a full and fairly careful examination of the legal basis of self-review. Maybe we need to cut it free from either the judicial review of administrative action or reviews under legality. I said it was a tributary of the existing swamp. It's now a whirlpool of uncertainty. So my words of advice, if not wisdom, are simply that we should follow Bill Sykes in the musical Oliver and say, I think I ought to think it out again. Thank you very much.